Hey everyone, welcome to another episode of PixlFeed Radio. I'm here with my friend Devin Miller. Devin, how you doing today?
Hey, I'm doing awesome as ever. No complaints.
Absolutely, I love to hear that. And for those of you who don't know, you're kind of a great mix. You're a partner at your own law firm, Miller IP Law, so you can see in the hat. I like that little marketing there. And but you're part of a few startups as well. That's how you got started. You're into patent and trademarks, which I find super interesting because I think there's a lot of misinformation about that out there. And I myself, being in e-commerce, I've been hit up by a couple of patent trolls thinking they can get away with it. But luckily, I'm married to an attorney, so I know how the game works. And but I've heard of so many scams and people falling for it. So I hope we can get into some of that, I'm sure, and then tell a little bit about your story. So before we get into the whole trademarks and patents and all that stuff, why don't we go back to the beginning when you were a kid? Were you always an entrepreneur? Did you always have like a side hustle? Were you always starting something, or did you take the what I like to call the normal pathway and just went to school and to say I'm going to be an attorney, and then just went to school to be an attorney? How did that go?
Yeah, probably somewhere in the middle. So I always loved to work as a kid, earn money, and I said I always would have projects going on. I'm sure I had a few side hustles, of which I probably or can't really recall any. So, but I always probably was a mix. So I also went to school, got an education. So I always joke that I got 4 degrees, which my wife says is 3 degrees too many. Which is, so I went to school, undergraduate, I did electrical engineering and Chinese. And that was about the time that I was saying, okay, I'm coming out of undergraduate. What do I want to do? And I grew up type of a thing. And I said, well, I like engineering, but I don't want to be an engineer in the sense that, typical engineer is you are a very small cog in a big wheel. You have to take, work decades to work your way up the company before you have enough experience to have any real impact on the business. And you never really get to see the full picture most of the time. And I said, that doesn't sound as exciting to me. So I'd rather do something else. And so I was kind of exploring, what do I want to do? And that was kind of, I was at the crossroads of, I love startups, love small businesses, thought that would be fun to do something on the business side. And I also thought that, on the legal side, that always sounded interesting to be able to work on patents and trademarks and copyrights and work with a lot of startups and small businesses, see what they're doing, help them out. And so that was kind of where I took I'm not going to choose one or the other. I'll just do both. And so I went off to graduate school. I did a law degree and an MBA degree at the same time. During that time, I was clerking as a law clerk. I also had started my first, what I would say, real startup, or one that was, looking to be an actual business. And then I've been pursuing that ever since. So I've kind of, I guess, pursued a duality of careers where I've always been doing startups and small businesses. And I've always been an attorney and working on a legal side. And so that's a bit of me in a nutshell, but that's kind of how everything's got started for me.
I can see how all those worlds can come together, like engineering and being in law, because it's a different way of thinking. It's more analytical and attention to details, right? But I do have one question. How hard was it to learn Mandarin? Because I speak 3 languages, but 2 of them are very related, so that's what makes it easy. But how hard was it?
Oh, it was hard.
Yeah. Did you go over there? Did you go to Asia for a while?
So, yeah, that's what I was going to say. So the reason I didn't really honestly have any intent to study Mandarin, to learn it or anything else, it was more of, so I served a religious mission for my church. So Church of Jesus Christ of Latter-day Saints, otherwise known as Mormon or LDS. And so I had a desire to go serve for my church. And so the way that it works is you say, hey, I want to serve. And then they will come back and say that here's where you're selected to go serve. So you don't necessarily have that input. And so I came back and said, you're going to Taiwan, which is also Chinese speaking. So At that point, I honestly probably didn't know where Taiwan was. I certainly didn't know anything about Chinese, but I was happy to go. And so I learned that, went and learned the language, was there in Taiwan for a couple of years. And then as I came back, I said, hey, I've already done a lot to learn the language. Why don't I add this on as a second degree? And so that's what I did at undergraduate.
That's pretty awesome. So you were immersed into it, and that makes it a lot easier. I always joke around, like when I moved to the States, I was 13, and I only knew the basics, like hi, hello, bye, blah, blah, blah. And I tell people all the time, I'm like, listen, I had no choice, man. I was thrown in school. Like my parents, like, yeah, you're going to school. And then between being immersed in school and TV, I watched a lot of TV. MTV helped me learn English. That's how I started picking up. And then one day, it's super weird. And I wonder if you had the same experience that I did, is that you're sitting there and you're listening to people talking or watching TV, right? And you're listening and you're listening and you're listening, but you don't know what's going on. And then one day, all of a sudden, you just realize that you understand what's going on, but it's really hard to explain. Like people ask me all the time, I'm like, it's really hard to explain. It's not like, you just memorize the words and all of a sudden it just one day you're sitting there and it's like, whoa, wait a minute. I know what's going on. I understand every single word. That is so cool, like the thing with me, and I think I talked about this before on here, it's like music, songs that I used to listen to growing up, and I had no clue what they said. And then one day I was like, whoa, so this is what this song is about, so, but listen, man, Chinese right now, you already know this, that's a huge advantage with all, especially if you're in the e-commerce and startups and all that stuff, because a lot of stuff comes from China. So do you get to use it a lot?
I would love to use it more than I do. I get to use it every so often or infrequently, but it's one where I don't have, I do something with China with business, with law, but it's one where honestly it gets to be the level of technicality in the language and what I'm drafting and doing to where it ends up being in English or they end up knowing for the English side of things better than I would for Chinese. So I know a bit more conversational discussion and kind of talking and whatnot. You get into the technicalities of inventions and electronics and software. I never learned that, and that goes right over my head. So it's kind of one where I get to use it, every so often, but would love to incorporate it more, and maybe someday I will have to.
I can understand that. I can see that too as well, because even I forget technicalities in other languages, so I get it. So what was the first startup? Like once you once you were in school, what was the first startup that you went into?
Yeah, so first startup, to set the stage a bit. So as I mentioned, I was doing a law degree in the MBA at the same time. I had a 2-year-old at the time. We just had a newborn as well. I was working 20 hours as a law clerk. And then on top of all that, and I can't remember if it was a flyer or an email, but I saw a business competition, and they said, you can come in. It's a multidisciplinary where you get attorneys and you get MBAs and you get designers and you get engineers. You put them all in a group and everybody comes up with an idea and they enter into the business competition. So I said, that sounds like fun. Why not? Don't have enough on my plate. Why not add one thing more? And so went into the introductory meeting with the competition, joined, found some other people, joined the group. And first year we entered in the competition. It was an idea to make gym bags less smelly. It was a cool idea. Don't know that it would have ever worked in reality, but it was kind of a fun idea. And so took second place, and that was about the end of that. But we came back the next year, and it was really kind of it said, hey, we were all juniors at the time. Now we're seniors. So why don't we enter in the business competition again? It was going the same year. And so I said, sure, why not? So we got together and we came up with different ideas, and some of them were just stupid, like sell packing boxes and other things that would never work. But as we were brainstorming, I remember that I was walking home after a brainstorming session, and I was trying to think, think of ideas in that. And I got to thinking, well, I just ran, I think my first marathon, and I love to run. And so I said, wouldn't it be cool if you could have a watch that could tell you your hydration level? It would help you with running. It can also help athletes with performance and whatnot. And so you got to think back, this was in the days before Fitbit. It was in the days before the Apple Watch, and there really wasn't a wearables category, but it was kind of a cool idea. And so from that, I went home, called up my dad that also had an electrical engineering degree, worked on some medical devices and whatnot, and kind of started brainstorming. Went home over Christmas, built up an initial prototype. We entered it in the competition. Took second place again, which I'm still slightly bitter on. But then we got to after the competition. I said, no, I think this is an actual business, and I think there's a reality to it that you could do something. And so I bought out the other business partners, what ownership they would have in it, and then I started a business around that. And so that was kind of as I was graduating, pursuing law or legal career. I was also full-time pursuing that business and growing that. That one's still around. It's still going. It's evolved now into a bit of a different wearables arena for diabetes monitoring, but it's a fun company, and still it was the first one that I started in legitimacy.
That's really cool, man, that you were able to pivot that into, diabetes, quote unquote niche. But that's really cool that you were able to have the vision and to do that. You just reminded me when you're talking about the watch, I think back in the 80s, I think it was Casio that came out with a watch where you could check your heartbeat. It's like, for some reason, like, I begged my parents to get me one and I will bring it to school. It was yellow. And people at school will go crazy. We will go crazy about it. It was the late 80s. So it was such a big deal at the time.
Yeah, that's kind of like the old watch that has a the calculator on it.
Yes, the Casio had that one too at one point. I was like, I can math hard, man.
That's right.
So now it makes sense from listening to your story, how you got into patents and trademarks, because I'm assuming with the watch, you had to figure out how to protect it and all that good stuff, right?
Yeah, and that was one of the things. So the very first patent I wrote from start to finish on my own was for a patent for that invention. So we didn't have a lot of money with the business competition. I said, hey, I think it's worthwhile to protect. And so that one, now I think there's upwards of, for the company as is, right around 100 patents on it, still going strong. And so, but that was one where, short to the story is, we were pursuing down the hydration route. We had another company that as we were getting ready to do our next round of fundraising, that we got connected with, that was in the diabetes. Now, they were more for the monitoring side and providing the services, not in the technology side, but saw a good connection there and a lot of overlap with the technology that could be applied with what we did in hydration. So that's where it got in. So that one was a lot of the valuation as we were coming in and doing a bit of a merger and taking both companies and putting them together. On our side, was a lot of it was to do with that IP and that patent portfolio is what justified our position in the company.
That makes a lot of sense. So now that we're talking about patents and all that good stuff, why don't we get into it? I'm sure, I know I have some questions about it because I've looked into getting patents and trademarks in the past. I never went through with it. But one piece of advice that was given to me that stuck with me for some reason, it's like, get the product out there and then worry about the patent and the trademark. Like, first check if it sells. Like, people usually, they try to be super careful about it and protect themselves. And the reason why I was told, because it could be very expensive. I looked into it, and when I'm like, everything that I have to do, all that paperwork, I'm like, I'm not going to do that. I'm going to hire somebody to do that. And obviously it's not cheap. So what do you think about that? What's your opinion on that?
I think it's good advice to a degree, and I'll give you a couple of caveats. So I think overall, to your point, if you never have a business that never makes it anywhere, if you never get a product off the ground or never make any sales, great that you have a patent. It's not going to do you any good. So within that, I think it's a fair point. Now, there's a couple of caveats that people also kind of on the flip side that they unaware of and end up running into. So on the patent side, this is a real quick overview for the audience as we talk, kind of splitting up what is a patent, trademark, copyright. Patents are for inventions, something that has utility, a functionality, does something. Trademarks are for brands, logos, name of a company, name of a product, catchphrase. Copyrights are for creative. So a book, a painting, a photo, a movie, a podcast, any of those that are on the creative side, that's going to be under copyright. So just kind of as a level set for those that are listening.
Hold on. Sorry. Let's slow down a little bit. So, okay. I never knew the difference. Actually, I never even thought about the differences. I always see the logos and I'm like, okay, it's protected. That's all I care about. So copyright, because you see like Coca-Cola, it says, does it have the trademark or the copyright logo?
It'd be the R with the little circle.
The R, correct. So, okay, so let's slow down. Let's break that down again, but slowly, just so people can understand it and so I can get it again.
So I was just going to give a level. So I'll break it down just a little bit more.
Yeah.
If you're to think of patents are for inventions. A device, something that does something. It can be software, it can be hardware, but it has to perform a function, have a utility to it.
Got it.
And then trademarks are for brands. So name of a company, name of a product, catchphrase, a logo, something that's basically associated with
Nike
brand. Then, just do it for Nike, got milk, melts in your mouth, not in your hand. All of those are going to be catchphrases. All those would be trademark. The last one is copyrights. And copyrights are, if you think of anything that's on the creative nature. So you take a photo and you want to do it, or you do a drawing, or you do a sculpture, or you write a book, or you do a television show, or you do a movie, anything that's kind of on that creative nature, that falls under copyrights. And so those are always kind of good things when you're looking there, keep in mind as to what you're wanting to protect with your business depends on kind of what aspect of your business that's valuable. Is it your brand and that's what you're building? You're going to want to fall under trademarks. On the other hand, if you're creating an awesome invention, you'll get a patent. If you're writing the next Tom Clancy or Harry Potter or Lord of the Rings or whatever you want to, whatever book genre you're in, then you'd want to make sure to do copyrights.
Okay, that makes a lot of sense. And I hope that makes a lot of sense for other people out there, because depending on the business is going to be different. Yeah. Okay, so, all right, go back to that. The reason why I was giving that advice was because I know how to sell a product and all that, but it was basically in the terms of like, before you spend all that money, make sure it sells. You know what I mean? Like, I guess, like you were saying, if you don't have the experience and never sold anything before, you're saying, you know,
I would say yes, get the product out, actually see if people are going to pay you for it, because great if you go get a patent, and I get into that, I definitely recommend it. But if you can't, if your business never gets out and all you have is a patent, and then you don't have anything behind the business, it's not going to do any good. And the idea that people sometimes come in or pitch or come into my office and say, well, what I want to do is just, I want to have an idea, I'll get a patent on it, and then I'll go license it. Well, 99% of companies, that doesn't work. Patents have value, but if your whole business plan is, I'm going to have an idea, get a patent on it, and license it, you're in for a reality check, in the sense that you've got to do more to show that there's actually a viable product, people willing to purchase it, and that it's otherwise has value, and then the patent adds on top of that. So now with that in mind, the one caveat I would give is there's a couple. With a patent on, let's say you had a great invention, there's a time clock ticking from when you put the invention out in the public. So if you put it up on a website, you put it up on Kickstarter, you go out and start pitching it to conferences or for venture capital, you do seminars, you do whatever. Anytime you put it out in the public, you get a 1 year time clock ticking, meaning you have 1 year from the very first time you put it out in the public within which you can file a patent on it. You miss a 1 year time or 1 year window, you've now just donated your invention to the public. Anybody can pursue it. Nobody can get a patent on it. So if you're wanting to get it proprietary and protected, you have that 1 year window.
So let's say I come up with the idea, blah, 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 put it out there, and I wait. I don't do anything for 6 months, and then somebody sees it and tries to file a patent for it. And I go, hey, wait a minute. I'm the one who came up with the idea. I can still win that? Is that what you're saying?
So you got to the second point. Might be able to win it, but not recommended. So 1 year, or on the one hand, you have a 1 year time clock. Max you can do once you put down the public is 1 year. The other thing you have to think about is the US, along with basically the rest of the world or almost all the countries, is a first to file system, meaning whoever files on an invention first is the presumptive inventor. So if somebody sees your ideas, comes along, files for it first, they're the presumptive inventor. They're the ones that, as far as the patent office is concerned, was the creator of it. Now, if you are out there first and you can prove it, you may be able to get their patent invalidated. In other words, you say, I was out there first. You're not going to be able to get a patent on it. You've just closed that door. You may be able to stop them from getting a patent on it, and everybody will be able to practice it. So again, your best position is if you're putting it out and you want to be the first to file on it, the first to protect it, because you're in a significant disadvantage if somebody else files in. Because the other thing is let's say it's a very competitive field and a lot of people are trying to solve the same problem. You may have other people that are working on the same problem. They have the same or similar idea around the same standpoint. You say, oh, what's the odds of that? It happens more than you would think, especially for competitive fields, because everybody sees that there is money to be made here. Everybody sees that there's a problem. There's a lot of times only so many ways to solve the problem. And so people will come up with similar solutions, and a lot of times a similar time frame. And so you do have to, on the one hand, balance your much better situation if you are the first to file and you have that 1 year time clock ticking. And those are kind of the caveat to, yes, I would get the market out or start making sales, get the money coming in, prove that the product is worthwhile. But you do want to be cognizant of, if your plan is to get protection and box people out and have that proprietary nature to it, you do have a window within which you can pursue it. Okay.
I love the way you explain it because it's very detailed. People usually give you the runaround. It's very broad definition of things. So, so with a startup, with a startup, like let's say with a watch, what was the route that you took from day one when you had the idea? Did you personally go for it right away for the patent right away, or did you started to make sure it worked? Or I'm trying to get people to get a sense of how you did it so they get an idea depending where they're at.
Yeah, I'll say how I did it, and then maybe I'll give a little bit of caveats as to what they might think of.
Yeah,
so I mean,
the
way I did it is, enter the business competition. We were with the other partners. First of all, we brainstormed. We had to have something that we were going to pursue, and we had to have something that even when we brainstormed, once I had the idea, I still pitched to the group as to, hey, where's the market? Who would buy this? Why would they buy it? What would that price point be? Do we have the ability to actually, maybe get something out in the marketplace if we can get it to work? Is it, what would that look like? And so kind of we had the idea, and then we looked to see whether or not there's an actual market for it. Once we did that, it was say, okay, no, I think there's a market. And we looked at it. It could be everything from military applications. It can be for the elderly population. It can be for athletics and sports and whatnot. And there's, several different applications to it or different markets that we could pitch it to. Then it was saying, okay, now that we think we've convinced ourselves there may be an opportunity there, then let's see if we can at least build a crude prototype that shows that there's a possible way that this may work. In other words, nobody's created one that I was aware of at that point, and still not aware of at that point. Nobody created this, nobody tried it. And so, how are you going to do this? And so, came up with a way that we thought may work, built a very crude prototype. It was ugly. It was not good looking, but it worked. And then we could try it out. And then we tested it for a bit. And I would go on a treadmill. I would drink a whole bunch of water before, and then I would run on a treadmill, see if I was dehydrated. I would, do other things to test and see if we could see hydration movement. And we did that. So we built kind of that very rough prototype to test out the work. That's at that point when, I filed for a patent I prepared and filed a patent. Now, I did have the advantage of, while I was an attorney at that point, I was a law student. I was working for a law firm. I'd had experience. And so it made it easier for me to move that to be able to reduce the cost by doing it myself, which a lot of people, you read online, hey, we can file our own patent. You can do it yourself. It's easy. Just go file a provisional. It's a one page. It's, there's a lot of myths to dispel there, because they don't know what they're doing, and you end up not doing a good enough job, or you end up shooting yourself in the foot, so to speak. But because I had a lot of that experience otherwise, I filed the patent. Then we continued to develop the product. And we probably took the next year or so to reduce it, continue to test it, iterate on it, get it better. And then at that point, I was doing it as a side hustle, which I really think is always a second full-time job. But I had a couple other people that are also working on it, and we went and got an investor, got some money infused, had some additional people come in, and then continue to develop it. So that was kind of and then later on, as we were getting ready to do our next round of raising, that's when we brought in the other company and we merged with them. But as far as the timing on when I did the patent, I probably did it a bit earlier than other people necessarily would have, because I said, hey, I can do this. I can do it at a lower cost. And the technology is such there that I think it's worthwhile to pursue. Now, I was also worried this is a competitive market. I think that, if I can figure this out, it's going to be worth a lot of money. We've already entered into business competition. We've told people at high level what we're doing. I want to get some protection in place. Now, if I were to say, where would I maybe do it differently? It's a similar time frame to what I would do on businesses, with the exception of, if you're working on prototyping, figuring it out, getting it up and going, you can probably test it and do it a little bit longer than I did, because, as opposed to I was saying, hey, I can file it now. Why not? You may say, let's get it farther along that path of development to make sure it's worthwhile for the investment. So that's kind of where I did it, but where I'd probably say if I were to be in a place where I was paying an attorney that it was doing it for me, I probably would have waited another 6 months or so before we would have pulled that trigger.
And here's my other question that I have with patents and all that, because I was told this a long time ago, and I never really looked into it. But is it true that if somebody has a patent on something, a product or whatever, and if you tweak it by 10%,
no,
you can get away with it or not? Because I was like, really? I'm like, it can't be that easy if you have to go, right?
So I think there's a lot of myths out there. I've heard anywhere from 10%, 20%, 30%. And what's the threshold? And I've even seen it on television. One of the shows I still love was Suits, and it was a legal show. And I thought I still think it's a fun, enjoyable show. But I think in there it was either like 20 or 30%. And they said, well, we're above the threshold and we're below the threshold. So we're going to be infringing. And it's kind of one of those where everybody that's a real attorney is like, That's just me.
Like when people are hacking a movie, so like, we're hacking into the mainframe, and it's just like a bunch of gibberish. I'm just kind of like, that's
exactly. We're hacking into the mainframe, and it took us 10 seconds to get around all the governmental firewalls.
Yeah.
There's no way you can really do that. And that's kind of the same thing. So no, there isn't a threshold. Basically, the way that it works is if you want to get around somebody's patent is a patent, you have a section that's called a claim section. It is a kind of a bullet pointed type section where you list, here are the essential features of my invention. And it could be 3 features. It can be 100 features, hopefully not 100. But you can list them and you basically say, my invention has to include A, B, C, and D. If somebody else, if somebody comes along and their invention includes A, B, C, and D, they infringe on your invention. They can't get around it. They would be violating your patent and they can't get it, or they couldn't proceed forward. If they can remove one of A, B, C, or D, so let's say they only have A and B and D and they don't have C, they've got around your patent. If they have A, C, and D, and they don't have B, again, they got around your patent. Alternatively, if they have A, B, C, and D, and then they add E, F, and G, because they still have A, B, C, and D, they still infringe your patent. So it's not a 10% or not a 10%. It's a more binary as to you have your list of the features that you claim. If they have that same thing in their invention, they would infringe on it, and they would be in violation of your patent. If they don't, then they're clear.
That makes more sense than 10% and then that's it.
And my question when I hear that, I'm like, 10% of what? Like, how do you even judge what?
Well, that's exactly what I like. When I was told that, I'm like, it can't be that easy, because why would you go through the trouble of like doing all that paperwork and all that if you're just going to change the color on it and all of a sudden, I'm in the clear, Yeah. The other one that actually a lot of people who are watching this or listening to this because they're in e-commerce and print on demand. And this is always wishy-washy. People ask me this question all the time. Like, I'm not a lawyer, dude. Like, I don't know. I know people can get away with it, but I don't know the law behind it. Designs. Like, I know, for example, I know Disney's ruthless with their IPs, which as they should be since they own it. But if I wanted to make a T-shirt with, let's say, Mickey Mouse, as long as I make it artistic or funny, there's a fine line where you can do that, and then you're in the clear, because a lot of people do it. So how does that work?
So that would be that would go away from patents because it's no longer an invention and get more into the world of trademarks and maybe copyrights, depending on what you're doing. First of all, I wouldn't recommend it. Disney's going to sue you if you get even close to anything they're doing. And even if they're not in the right, even if you may be someone in the right, they're going to sue you anyway. And you're going to pay a whole bunch of money and probably lose because they're going to
they have like a whole army on retainer that it doesn't matter. It's like, just send the lawsuit out. Exactly. We just protecting them.
So they're very aggressive. And they're saying that's where all of our business is. And if we let people start doing it, we're going to lose out on a lot of our revenue.
No, I get it 100%.
But so now to your question is it depends, first of all, whether it's a copyright or a trademark, because that would be the first question. If it was a Mickey Mouse, that's more on the copyright side, but they've also used Mickey Mouse a lot for their branding and for that. So that one almost has aspects of both. It could be branding because they use Mickey Mouse and a lot of the branding. They have trademarks. They also have is creative enough. Somebody drew Mickey Mouse and it's different things that they're going to have a copyright. But either way, let's say there are two different standards. So let's say you were let's make it a little bit easier just to conceptualize. Let's say you wanted to just simply start using Disney on your branding and start to say, hey, I'm using Disney as part of my brand. And you say, okay, but what I'm going to do is I'm going to misspell Disney. So rather than spelling it Disney, I'm going to spell it Disnee, some variation. That would be on a trademark issue. The problem with that is trademarks they cover anything that is confusingly similar to a trademark that's already out there. So if people were to look at it and say, hey, I see Disney that's spelled with an E, I spelled the Y, they're probably related. They probably have something to do with each other. They probably come from the same company, or they have a licensing deal or something that you just now infringe a trademark because it's confusingly similar. On the other hand, you spell it, Disney with a D-I-S, I don't know. I've got to think of a better way to spell it, but it was something that wasn't confusingly similar. It was far enough away to where you're not going to think it's the same thing. Then you're starting to get into the area to where you're fine. And so it's really that confusingly similar standard as far as trademarks go. If it's something that people are going to think it comes from the same company, you've got a problem. If you can show that, no, that's really, there wouldn't be an issue there, you're probably in the clear. And then there's that gray area to where, you're always just trying to guess best of all.
Okay, I can think of a better example that's not Disney, and this is it's hilarious to me because it's South Florida, Miami, and I remember seeing this shirt and I laughed my ass off because this was in South Beach, and which there's a reason I don't go often to South Beach, but there was a dude walking around. There was a shirt and it looked like the Coca-Cola logo, like the old school Coca-Cola logo, but instead of Coca-Cola, it said cocaine. So, is that trademark infringement or is that satire where you can, because I mean it's Miami, so who knows who did the shirt, but I'm just saying, it's something like that.
It's probably a bit, I'll guess, because not seeing the shirt, I don't know, but it's probably a bit in the gray area.
Imagine the Coca-Cola logo, like the can, but instead of Coca-Cola, it just says it looks exactly the same. But
so you've got a couple issues. One is that Coca-Cola actually has a design patent for the shape of the can. So if they're using the can, that's different than the word that they're doing. Now, the second part, let's say that they didn't
think of the squared logo. When you see it like on a billboard.
Just take the logo, nothing with the can, and I just have the logo.
Yeah.
Then the question is are they playing off of Coca-Cola, trying to get people to think of Coca-Cola with their brand? And that's where they're going to probably get into trouble, because why are you doing it with that specific font, with that specific color, making it look the same?
It's
because
funny.
You want people to think of Coca-Cola when you buy the shirt. And so you're going to, it's one of those gray areas. You may be able to get it into satire land, but you're still going to get sued under there because they're going to come after you either way, especially, if it's somebody that's making shirt and selling on the beach and they never find out, great. They're probably not going to care. But if you're selling online and you're selling tens of thousands or hundreds of thousands of dollars, they're going to come after you because they're going to say, well, yes, people may not think it's exactly the same business, but you are still playing off of our brand. They're still thinking that there's some tie to Coca-Cola. And so it's going to be one of those gray areas. You're going to say, nobody's going to think that Coca-Cola is really selling Coke. And so it's one of those gray areas to where you may be able to you probably have a slight advantage as far as on the legal aspect. In reality, you're going to get sued into oblivion by Coca-Cola because they have a lot more money. So
and listen, and I got a little story for you. Like when I was starting out, this is like a decade ago, a buddy of mine who started at the same time as I did. And this is when Facebook ads was the Wild Wild West. There was no rules. It's like you could pretty much run ads for anything. People will sell like licensed stuff all the time. And he, like with me, I think I sold a couple, but it wasn't a big deal. I didn't even make that much money because I was in my head, I always wanted to make my own brands. So I never went that route for the quick cash. But I had a buddy of mine. He decided to go for the quick cash, and he got a hold of a Star Wars mug from China, of course, that when you pour coffee in it or anything hot, it will turn into like a lightsaber type of deal. The lightsabers will light up or something like that. Well, he decided to run it one Christmas, like the first year or second year. And of course it blew up because nobody was selling it all at the time on Facebook. And he made, I think at one point, I think it was like 70 grand or something like that. And it was like a week or 2 weeks, something crazy like that. So that gives you an idea how much these licenses make, right? How powerful these brands are. And I told him, like, dude, I'm like, you're playing with fire, bro. Like, that's Star Wars. Like, it's like, we're not talking about like some underground, toy, like freaking, Transformers before the Transformers movie came out or whatever. I'm talking about like, I don't know, man. I don't know. If I was you, I would just take the cash and run, and that's it. Shut down those ads, take the site down. And what happened? He got greedy. It's Christmas. He got greedy. So he kept going for another week. Yeah. And then I get the call, bro, I'm freaking out. I don't know what to do. Like, Disney's suing me. I'm like, dude, like seriously, you're surprised about this? Like, what should I do? I'm like, my wife is not a trademark lawyer, so she can't help you. And even if she did, like, she wouldn't help you because it's like, what you did. And yeah, man, he got sued by Disney on a lot of money. I mean, I haven't talked to him forever, but I mean, last time I checked with him, he was in court in the whole 9 yards and had to pay a lot of money back. And they destroyed him. I mean, they really did. And that's what I tell people all the time. People ask him, like, dude, if you have to ask if you can sell it, that's a straight no right off the bat, right?
Yeah. Well, or you go get the license. I mean, that's the other one. If you're really going to use somebody else's brand, go pay them. They did a lot of work to build that brand. And that's why I don't feel, while I get why Disney and Star Wars and other ones are very very or aggressive is because this is what the value of their business. And so they're saying, hey, we spent years and millions of dollars in advertising and getting it out there to build this brand. And if somebody comes along and all of a sudden just puts something out there and making money off of our brand, we just lost out on all that revenue and that sales that we have done to build that business. And so I think that, yeah, if you're getting to the point where if you're having to ask the question, well, is this okay? And maybe not. You're better to build your own brand, do your own thing, and establish it just like everybody else had to. And then you're able to do the same thing. You're going to box people out. You're going to get it proprietary. You're going to get that trademark or that or copyright or anything else, and then build your business to be sustainable. Because to your point, maybe you can make a little bit of money off Facebook ads. And if you're under the radar and you don't hit their radar, you might be able to make a little bit of money. But if you go for very long, they're going to catch you, and they're honestly getting a lot more sophisticated. They run their
you can't do it now. There's no way you can get away. Yeah.
Facebook's monitoring it. They have all of their people monitoring it. They watch everything that's used on the internet, and you're not going to get away with it very long. And if you do, you're going to be one of the lucky ones. So it's always better to just either one, get a license if you really want to use their stuff, pay them for it, pay the percentage, or two, start your own.
And it's worth it because it's powerful. There's a reason why that brand is powerful. And yes, it's probably going to be expensive to get that license, but guess what, man? You got that license, that it's going to print money for you if you do it right. So, and people, it's like, well, stick it to the man. I'm like, it's like you said, these are brands have been built over decades. You know what I mean? And they're protecting their brands, and I don't blame them for it. If I had a brand that big, I'll be like, no, you can't use it. Like,
and the irony is if you talk to the same person, let's say they did put in all the work to build their own brand, and somebody else came along and copied it, they would be like, I'm going to sue them. There is no way. Look at they're copying me. And it's like,
absolutely.
Yeah, you get it. If you're on the other side, you don't want anybody copying your brand any more than you would, than the other people would you copying their brand. So I think that turnaround is fair play. If you're saying, hey, I want to build my own brand, I don't want other people to copy it, you need to be respectful of others' brands.
No, absolutely, 100%. So let's get into the other side of things, which is patent trolls and trademark trolls and all that good stuff. So I've gotten the emails of like, hey, you have something on your site and it looks a lot like our stuff. Send us $500, or like, it's a law firm. And it's like, we're going to charge, either you pay us this or, we're going to take you to court. And then at some point, it's like, let's go to court. And then we go back and forth a couple of emails, and then they disappear because they're paying an hourly rate, I guess, and they have to go. But what's your thoughts? Your thoughts on that?
I'm split. I'll give you why. I'll give you a better answer than just, there are some that are just terrible actors that I think that are giving the community a bad name. And I think that there is a role in a place that they can be good actors, but the good actors are a much smaller percentage, and you got a whole lot more bad actors than good actors. So let me give you a little bit of reason why. So let's go on the patent troll, because that's one that one probably usually hits the most, and it gets a lot of, more notoriety. And just for those that are listening, a patent troll is basically, they go out and they will buy patents. They don't have a business. They don't create a product, and they will just simply go and sue everybody that they think is reasonably infringing the patent. Sometimes they just sue everybody, even if they don't really think they're infringing the patent. And their business model for those type of trolls is, hey, we will just file enough lawsuits or send enough letters that we will play the odds, and we'll have a percentage of people that are willing to pay us to go away. That, I think, is a bad actor. If they're going in with the sole intent of, we're just going to try and sue everybody, scare them off, we're going to try and make them, pay a fee, and we don't really do any due diligence, we don't really care if they're really infringing, and we're just going to do it because we have enough money that they'll probably pay us to go away. That, I think, is a bad actor, and they shouldn't be allowed to do so. On the other side, if I were to say now, there are the potential to have good actors, and I'll give you a good actor example. Let's say you are a small business and you come up with the world's next best smartphone, and you think it's a great technology, it's groundbreaking, it's next generation, nobody's doing it. You invested all of your life savings in it. You've invested 5 years of your life, and you finally get it up and running, and you get a patent on it. And then somebody comes along, whether it's a Samsung or an Apple or what are the big players, and they just say, that is a great idea. Now we're going to go put it in our phone. And guess what? We're not even going to pay you for your patent. We're not going to pay you for technology. We're just going to rip you off, and good luck trying to sue us because we got a whole bunch more money than you do. Then you're stuck with a couple options. One is you can try and go fight them in court. If you're a small dog, you can win, and people do, but you're fighting an uphill battle from the financial side. Two is you can, let's say it was, and I'll pick on Apple just because they're very litigious. But let's say it was
don't
Apple.
Even get me started on Apple right now.
I don't want to get Apple to sue me, so I'll be careful.
Yeah.
But let's say that they, Apple came and just blatantly ripped it off. Well, another option is you could go to Apple's biggest competitor. Let's say you say, hey, we got this great feature. We've got a patent on it. We've got all the technology. Apple ripped us off. You go to Samsung and say, hey, Samsung, your biggest competitor that just released this feature, they're in violation of our patent. We can't enforce it, but you can. Why don't you acquire us or take a license from us? And that's another viable option. That's another.
I like that. I never heard of that thought before. I like that a lot. Like if you don't have the money, pair up with the main competitor. It's like let's double down here.
And sometimes you may go to the second or the third level competitor. So sometimes the second competitor says, "Oh, we've got a whole bunch in the works," but that third or fourth that's looking to make the leap is saying, "Okay, we'll do it." So that one's another good option. I'll get to the patent troll, which is the third option. And, now you're saying, okay, I am a small time inventor. I have put all my money in here. I don't have the ability to do this. But you have these law firms out there or patent trolls out there that they are in the business of enforcing patents. And in that case, I think that it's a good opportunity because they're saying, hey, we're not, you've got a small business that can't do it. We're going to have a patent troll, and they usually take a pretty good percentage. They may take upwards of 50+%, but they are of the damages from the courts, but they bear all the risk. They have all the costs, and they're going to go out and enforce your patent such that you are able to. They have the wherewithal to go and have the experience to take on the big Goliaths and be successful. And so I think in that sense, some of those patent trolls, and they are a much smaller percentage of the community, do have a place where it's for those businesses and those companies that can't do it themselves, they can have an alternative to say, we do have valid IP, we do have valid patents, we are trying to bring this to market, and we're getting squashed by the big guys, and then there's a collaboration there. So that is where I think patent trolls, and similar with trademarks or copyrights, do have a place. I don't know that I would call them trolls, but they kind of get lumped in the same. If you're just suing everybody just to make everybody's life miserable, not a good business plan. But I think if you're doing it in that perspective, then I think that there's a place for them.
Yeah. The other, I wouldn't say patent troll, but the other one that I've gotten a few times, and I know a couple of friends of mine, they call me freaking out too. It's happened to them. I call them photography trolls. So, there's plenty of websites out there where you can get royalty-free photography or stock photos and all that stuff. So you can use it on your website and all that stuff. And I know a lot of people they fall for this one where they get an email and they're like, this picture that you have on your site, you need to take it down and pay us $500. I don't know. But they make the email seem super, legit and all that good stuff. And, I know where my pictures come from every time I built a store or whatever. So I'm like, no, I'm like, no, or I just ignore the emails. But I've had friends who paid up and I'm like, why did you pay if you got the picture from like Pixel Bay or one of those stock photos? Like, what do people need to look for? Because if you're getting up, if you know that you're getting your photos from the actual royalty-free resources, and let's say it's Adobe, like, right. But somebody's like, no, that's my picture. I mean, should you respond and just be like, take it up with Adobe? Don't take it up with me. I got it from them. How does that? What would you recommend in that situation? Because I just ignore it, but I don't care. I mean, it's people that freak out.
First of all, do your homework and see, is it legitimate? Because sometimes you'll have employees that you tell them over and over again, only use these legitimate sites, license images, and then they do a Google image search. They find the best one, they right click, save as, and they put it up on your site. So sometimes it is legitimate, even though you don't. So I would make sure, first of all, do your homework before you just ignore it, and at least look to see it. Hey, where did we get this image? Are we clear? If so, then yeah, to your point, I would go to Adobe and say, hey, we received this letter, just wanted to verify that this is a licensed image and that we don't have any issues. And if they're a big company, they'll probably respond and say, yes, here's the license and it looks like you're cleared. And then I would ignore it. Where they're a lot of times preying on the small businesses, they're saying, okay, they're going to go at a low enough amount that yes, you could go and ask an attorney, but it's going to be about the same cost to go and ask an attorney and have the attorney look into it as just paying him off. And so it's that where, well, I could either go pay an attorney a couple $100 or I'll pay them a couple $100 and they'll go away. And that's kind of the business model. And I think that one is, again, a bad actor. One of the even more egregious, and I think it was Pixel Bay, but I won't put their name out there because I'm not sure. So I'll just say other one is they used to be, and I think that some of these sites are more legitimate, but they used to be almost that kind of same troll, to where what they would do is that they would let you have a free or a free or near free version that was used for personal use. In other words, they would say, yes, you can get this for personal use. You pay a minimal fee, and they're just saying you can use it in presentations for school or whatever. And then but they would make it very confusing. They would make it sound like you're getting a license, like you're in the clear. People would get it thinking that they're clear in the licensing to go and use it on their website or with their products. And then they would get the letter, and it was technically a legitimate letter in the sense that, hey, you didn't pay for the license for all commercial uses, and you only paid for the very minimal license to do it for personal use. And then you would be stuck in it. And that was, I thought, was even more egregious, in the sense that they are intentionally trying to misrepresent it while being within the legal bounds, such that you are downloading and using their images just so that they can come and sue you. And I think that one is, there's still some out there that are bad actors like that. It's been cleaned up a bit, but that was the one that I always thought was the most egregious. To your point, check where the letter is. If it looks like it's, if you have the image from the legitimate source and you're fairly in the clear, I would go ahead and ignore it. If it's one where you don't know where your employees got it from and you can't verify that you licensed it, then you're probably going to want to pay more attention to it.
This is what I tell people all the time. If it's online, assume someone owns it. That's number one. Just because it's online doesn't mean like no one owns it.
Just because you can Google it and it comes up in the Google search doesn't mean you can use it.
And I have the perfect example for that. Another one of my friends called me freaking out about it because I'm the internet guy. And he owns a real estate brokerage. And don't assume that because anyone has access to it, it doesn't belong to anyone. Yep. He grabbed a picture of a home from the MLS that looked amazing to use it on the cover, on the homepage of his own website for the brokerage. And guess what? He got sued for using the picture. And guess what? He lost because that picture belonged to the MLS.
Yep.
I mean, it wasn't millions of dollars or anything like that, but he lost.
And that's I think it's great advice. Every image, song, video clip, assume somebody owns it, and if you don't have permission from them, don't use it. Go get a legitimate
license. In writing, email. If they say sure, you can email. Paper trail.
Well, if you're really going to use it to build your business, get a licensing agreement, not just an email.
Yeah.
In any event, always get in writing. The old adage with attorneys is if it's not in writing, it didn't happen, because somebody can tell you something, then they'll change their mind when it's beneficial to them. But I think that, to your point, first of all, a lot of people don't even realize there's what's called reverse image searching. And all you have to do is, if you want to see if somebody else is using your image, you put it in the search image. It will go and scour the internet and find every instance where people are using it. And then you have a list of, here's everybody I can sue that's using it. And now I can legitimately put it out there. The other thing is I like your point, is just because you see a lot of people using it everybody may have paid the licensing fee for that image, or everybody may have permission to use it from the original creator, or whatever the case may be. Or it may be that they are part of an organization that does have a license, and so it gets put out there and you see it everywhere, but everybody else has that right to use it and you never paid that. So I think, to that point, assume that people own it, and assume that you have to pay in order to use it. Absolutely.
Man, thank you so much for all the explanations and all the great advice. We're unfortunately out of time. We're a little bit over. So, and I have so much fun in podcasts like this when I completely lose track of time. But before we go, you're the host of a podcast, the Inventive Journey. Tell us a little bit about that.
Yeah, so I do a podcast, Inventive Journey. I think we're right over 300 episodes now. So time flies by. Amazing. And it's a great time. But it is really set up for, so as you probably got through all my conversation, I love startups and small businesses, work with a ton of them with my law firm. And so the podcast really started with, I would always hear a lot of the same stories of everybody's business is different, but everybody kind of felt like they had to wear multiple hats. And it was a lonely journey because nobody else knew what it was like unless you're talking to another startup owner. So,
yes, that is true.
You have to do marketing, you have to do sales, you have to do HR, hiring and firing. You're the janitor, you're the boss, and you're the legal department, and you're everything else and it's just like, man, I'm overwhelmed. And I feel like everybody else has got it figured out, and everybody else has, got it, and they were the overnight success. And why is it taking me so long? And I heard those stories enough that it was really started the podcast to say, no, why don't I take and share a lot of those stories that I know that are people that, overnight success is 10 years in the making. And they started out, they didn't go to school, or they went to school and they worked for a big business. And then they went and did their own thing, and they had a side hustle and that failed. And then they started another side hustle, and whatever that story was, that was really where the podcast came about, is kind of sharing those stories so everybody can hear. Everybody's journey is different. There isn't one way of doing it. And the biggest thing is, persistence and pursuing through the journey and doing what you love. So that's really where the podcast came. And it's not as you mentioned, it's called the Inventive Journey. It's everywhere. You can get it on YouTube. You can get it on our website. You can get it on all the podcast platforms. And it's just a fun conversation where every time I interview a different founder, co-founder, entrepreneur, startup, and how they got to where they're at today.
I'm glad you're doing that, and I'll have the links in the description and all that. But I'm glad you're doing it that way, because people tend to focus. And I used to do this when I was getting started back in the day. People focus on the success, but they don't know how long it took to get there. Like listen, like to where I'm at now, it took a lot of hard work and a lot of failures and a lot of nothing. And I mean nothing as getting no results. It wasn't overnight. I'm telling you, because I know what it feels like, because I was there. When I first found out the whole, internet marketing, digital world, e-com and all that, we'll follow these guys who were already millionaires and successful. And I'm like, why am I not there yet? But the reality is that now that I'm friends with these guys and I know their stories, they were already doing it 10 years prior to that, when it cost $300,000 to build a funnel. So I'm so glad you're doing it that way, because more people need to hear that message, especially with the younger generations, with Instagram and TikTok and all that anybody can rent a house or a car, and they believe everything they see. Just don't let it get to you, man. Do your own thing. That's what I tell people. And I know it's not easy, but you have to understand that it's not overnight. It's never overnight, very rarely. So
I would say 99% of the time. And that's, I said, everybody, even when I originally started out the podcast, everybody just wants to jump into what they're doing today, the successful business. And it was really saying, no, let's back up. Let's tell that whole story. And then they're like, oh yeah, I never really thought about all the steps that it took me to get here, but it was a big journey and it was a lot of up and down. So I love it. And if nothing else, I get to hang out with a whole bunch of cool startups and small businesses. So
yeah,
it's
for
a fun
sure.
podcast.
All right, Devin, where can everybody find you?
All right, I'll give them a couple ways. If they want to one-on-one free strategy, meaning if they have questions about patents, trademarks, copyrights, anything else with their business, they can jump on free of charge, 15 minutes. We can talk and strategize a bit with them. They can just go to strategymeeting.com. That links right to my calendar. You can grab some time on it. Strategymeeting.com is a great way to grab a one-on-one with me. If they just want to find out more about the law firm, they want to find out more about, what our prices are. We have a ton of content. We have video for those that like video. We have written content. We have the podcast. We try and hit as many avenues for however you'd like to learn. You just go to Law with Miller, all one word, lawwithmiller.com, and that links to our main website. So strategymeeting.com if you want to grab a one-on-one, lawwithmiller.com if you want to grab or just find out more about the law firm.
Right on. And all links below in the description. And Devin, thanks again for coming on, man. That was a lot of fun. Thank you so much. I really appreciate it.
Absolutely. I had a great time. Thanks for having me.
All right. Till next time.